Showing on Law Weekly today, perspectives from the bench on the introduction of virtual court hearings. We have the views of a retired judge of the Lagos State Judiciary, Justice Olushola Williams, on these and other issues. How can virtual proceedings work better? The Chief Judge of Lagos gives us an insight. That's our lineup on this episode of the program. Hello and welcome. I am Shola Shieli. My guest, Justice Olushola Williams, was appointed to the bench in May 2001. At different times, she sat on lands, commercial, fast track, as well as anti-corruption cases. She also sat on several high-profile criminal cases while serving as a judge of the Lagos State Judiciary. She was a member of the Judiciary ICT Committee before her voluntary retirement from the bench in August 2019. In this interview, I began by getting her views on the much talked about issue of virtual court proceedings.
Well, it's a welcome development, and it's something that I wouldn't say it's been long overdue, because nobody expected a situation like COVID-19, but there were times when it was necessary to have remote court hearings, but we were not able to. And now we're pushed into it. So it's a welcome development in that regard. And it would be nice if it continues beyond this time, because we certainly have situations that call for having remote hearings. But there are reasons why we didn't have them before.
I'm sure you've been following the arguments that some lawyers have been making about the need to exercise caution with the use of virtual proceedings, especially in criminal trials. Some lawyers say that the practice directions are not far-reaching enough. There are issues of when the accused person is on bail, where would he be? Would he be with the judge? Would he be with his lawyer? Would he be on his own? There are also those who say that when there's no face-to-face interaction, you can't readily read the demeanor of a witness.
I think that argument, with much respect to most of those who have it, is a bit short-sighted, because virtual hearings are not meant to replace regular hearings, and they are not meant to be the order of the day. Virtual hearings should only be heard when situations require it, like COVID-19, for instance, or if for some reason a witness or a defendant cannot be brought to court. So it's not a one-cap-fits-all. What we just need to do is to define the circumstances in which you would apply virtual hearing or not. And you make an application giving reasons why the court should embark on a virtual hearing. The court looks at it like every other application and then determines that, yes, this situation calls for a virtual hearing. So it's not every time. So to, for instance, say that where will the defendant who is on bail be, it would depend on the circumstances of the case. If someone is on bail, he ought to be in court when his matter is called. I can't imagine what reason he would give. Now, if that person is ill in a hospital outside the country, for instance, and is ready to testify, and we find reasons for it, obviously then you can apply for a virtual hearing. So it's not a case of a defendant is on bail and he has gone on a junket to a party, or he just doesn't feel like coming to court. Situations must require virtual hearings. Now, the argument about demeanor is ridiculous, because we've gone past that. When you have a pathological liar in the box, his demeanor will be the best you can have. So that is not the only or really major way of telling when someone is telling the truth. Maybe in the days of old it was very relevant, but now we have documents, we have so many other things that you can, in fact, abroad they have lie detectors, for instance, so you have many things and many ways in which you can find out if somebody is being truthful or not. It doesn't have to be the question of the demeanor. And unfortunately, this pedantic view, this old-fashioned view, has actually affected a lot of our hearings. And so many reasons why we should abandon this thought that unless you see someone face to face, you can't tell whether they're lying or they're telling the truth.
What about the issue that, well, if we conduct virtual hearing, if the witness doesn't want to answer a question, he will just blame it on poor connectivity?
Well, he does it at his own peril, because indeed, that is not even a good argument, because you are in court and people don't want to answer questions. If someone doesn't want to answer a question in court, are you going to beat him? Are you going to force him? No, you make some presumptions based on the fact that he's not answering the question. And that's what the law says, that if you are able to give evidence and you don't give evidence, the court can make presumptions based on the fact that you didn't make some things available. So if I say, oh, I have bad connectivity and I switch off, isn't the connectivity going to come back sometime? The question will still come back. So if I ask you this question 3 times and it's every time we ask this question that your internet goes off, then I can make, the necessary presumption. Yes, from there.
What about those who say virtual court hearings should be limited to judgments of the trial courts, and then maybe the rest of it could be done at the appellate court levels?
It is in the trial courts that the bulk of the work is. That's where deep down in the trenches that you need, the appellate court most of the time works on documents. You bring the evidence that has been led and the judgment, and that is all. They are not holding hearings, they are not calling witnesses. So that's ridiculous, because appellate courts can work with or without virtual hearings, but trial courts have a bulk of work to do.
So
that if you keep waiting, they need it more than anybody else. Because if the trial courts keep waiting, then what's the appellate court going to be determining? So the trial courts need it even more than the appellate courts, I make bold to say.
What for you are the lessons from this pandemic, and what do you think that lawyers and judges can learn going forward post-COVID-19?
If we had certain things in place, we would not have been caught napping, as I put it. And that is why I said, although I wouldn't say the issue of remote hearings is long overdue, it is something we should have been prepared for. And we need to have, for instance, a standing committee on ICT. If we had that standing committee on ICT, we would, this issue of, for instance, we've got some complaints that courts are embarking on remote hearings without waiting for the National Judicial Council and all that. We wouldn't have that, because the ICT committee would immediately have started thinking of, okay, we have these things in place, where do we go, what's the next thing? So a situation where every chief judge is calling on some of their judges or something like that to determine what to do, that it really isn't the way, to progress. If we had a standing committee, immediately this matter would have been referred to them and they would have said, oh, this is the improvements we need to make and these are the things we need to do. So that's one lesson, that we should be proactive. We shouldn't wait for things to happen before we react.
Now, away from issues of COVID-19, I covered some cases before your court. There were some high-profile cases criminal cases that you handled. But from your experience, share with us some of the challenges that judges face on the bench.
I remember we had a chief judge whose vision it was that we should have something she called a full court. That is a court that's the prototype court, that has what you expect every court to have. Maybe every court won't have it, but that would be the ideal model that everybody will be. She had that view. She set up a committee. But like I said, issues of continuity in Nigeria, that committee fizzled out and all that. So you have everybody saying, oh, why are judges still writing when development requires? Judges are scared stiff that I would not write, and then my recorder would tell me, which has happened to me before, that, oh, sorry, I wasn't recording, or there was no power and all that. So we don't have the infrastructure on which we can put a lot of things.
And so you can't afford to take chances.
You can't take chances.
The infrastructure is working.
Exactly.
So you have to write.
You have to write. For a long time, I was told that I had recording, I had a recorder and everything. We didn't have the tapes. So I was writing. Who would like to write when you can easily record your proceedings? But I would rather write and have my records that we can compare. There's that. There's a lot of problem with infrastructure, and there's a lot of problem with training. And that is why I left the bench to set up a training institute. And I'm very serious about it. You have staff who have no clue. So I have a recorder who doesn't understand legal terminology. And so when she's typing some things, I'm saying one thing, she's typing something else. So the staff to work with us, they do what they can, but they're not trained. They're not trained, let me say, fit for purpose.
So these challenges made you leave the bench, because I hear that you even left the bench before you turned 60, which is way early.
I wouldn't say the challenges made me leave. My dreams and my visions that could not be realized on the bench made me leave. And this Institute of Paralegal Services is a dream I've had, and it came out of the burden I had for this, that we need to face this particular challenge of training the staff. And I felt that, I would be doing better. There are many people who are judges, but there are not many institutes of paralegal services.
I also want to take you back to, your time on the bench. There's this back and forth between the bar and the bench about who is responsible for the delay that we see in court cases. These days you hear that the dockets are very full. Even at the Court of Appeal, they are giving them dates of 2-3 years in advance. This is some of the things that lawyers tell us. Where do you place the blame of, full dockets, delay in court proceedings, and it seems like justice is never served when it should be?
There are so many things that are responsible. Our laws are archaic. So if you ask me, I will hold our legislative houses responsible to a great deal, because the laws that have been interpreted are the laws that we have. So nobody is making laws. Granted, you cannot make laws for the bench and the legal arm of society without calling in judges, but there must be new laws. I talked about the issue of demeanor, for instance. It is so ridiculous that in the 21st century, Nigeria is saying that you have been hearing a case for 7 years, then the judge dies, is promoted or something, and say you have to start de novo because you want to look at the demeanor. Where is that done? What is the point of having records? So those things, that is a legal issue. It's a question of the law. It's not the fault of the judge, and it's not the fault of the lawyer. But there are also lawyers' faults. We have no doubt about that. And lawyers, of course, go for stay of proceedings when they shouldn't. But all those things a judge can actually deal with. So I would say that the delay is on both sides. Yes, judges have issues of infrastructure, but I always say that there are petitions all the time. If you find a lazy judge, and it has been happening, they're disciplined. But who is disciplining the bar? Who is stopping lawyers from asking for adjournments and refusing to turn up in court and all that? Even you have a regime of cost. When I was in the Ikorodu division, I was awarding costs of 250,000 naira if I fixed a trial and you didn't come. And there was such a hue and cry about it. But I didn't mind. You can go on appeal, but I'll go on with my trial. So it's on both sides.
Talk to us about some of the reforms, some other reforms that you would like to see in the system.
Well, one of the things I've always talked about is the regime of cost, and it's happening now. Still, when we were in the committee to renew the rules, I remember that when the rules came out and they talked of costs of over 50,000 naira, one lawyer from Ikorodu bar came and said, "My lord, I know you are the one that was responsible for that." So yes, Nigerians have to understand that time is money. So if you are not going to come for proceedings, then you must be ready to pay the costs. Then there's the issue of sifting cases. We cannot have a situation where every case goes for trial. Every case, we put it in the rules that cases should be screened, and you screen some to ADR and screen some, and lawyers fight that tooth and nail because they don't understand that they still have a role in ADR. So those
they fight tooth and nail to go to litigation.
Exactly. So some of them won't even go to the multi-door courthouse. So I think maybe training of lawyers, maybe more sensitizing of lawyers to understand that you still have a role in ADR. And you need to understand that time is money, that you are losing a lot by delaying cases. I don't know what anybody on earth thinks they're gaining by delaying cases.